Welcome to the land of 10,000 claims. Thank you for joining us here today. To celebrate our first episode, we're going to give a little bit of introduction on myself and my co-hosts. We're going to talk a little bit about workers' compensation generally. Then we're going to get into some phishing cases. That's right, phishing cases. Thanks for joining us. Welcome to the land of 10,000 claims. My name is Eric Schwab, and with me here today, I have my co-hosts, Mike Johnson and Scott Ferris. Now, here on the land of 10,000 claims, we like to discuss Minnesota workers' compensation. Minnesota, obviously being the land of 10,000 lakes, also happens to have about 10,000 workers' compensation cases per year. Now, before we get going on any discussions here today, I need to point out that all three of us are lawyers, and we're going to be talking about a legal topic. However, nothing here should be considered legal advice. You are in luck, though, because if you do want legal advice, we do represent injured workers in the state of Minnesota. All of us are attorneys at a law firm called Fields Law Firm. That's Fields, and we can be found at fieldslaw.com. That's Fields law, LAW.com. And you can reach out to us, and we're happy to provide legal advice there. And if you do go through there, just let them know that you heard about us through the podcast, because we'd like to pretend we're actually doing work here. So before we get started on some of the cases today, I think it's probably best to learn a little bit about all of us. So Mike, why don't you introduce yourself and tell people, give them a 30-second rundown of what workers' compensation is.
30 seconds. Okay, tough.
Good luck.
My name's Michael Johnson. I'm an attorney that's been practicing workers' compensation law exclusively since 2013. So it's been about 8.5 years now. I did defense work for 7.5 years before making the switch to Fields Law Firm and becoming a plaintiff's attorney. A workers' compensation in general, in a very small capsule, is basically in the state of Minnesota and many other states as well. If you get injured while at work, performing work activity, then your rights to recover any sort of medical or wage loss benefits from your employer and their workers' compensation insurer are limited by the workers' compensation statute. And one of the things we're going to explore on this show is how many exceptions to that rule there are, and funny defenses that can arise on claims. And also how the law has changed since the statute was enacted in 1913, which is now over 100 years ago.
All right, Scott, why don't you introduce yourself a little bit too, and could you talk maybe about what course and scope means, because that's something we're going to hear a lot, especially in these cases today. Could you explain what that is, and then tell us a little bit about your background?
Yeah, so Scott Ferris. I've been practicing exclusively workers' compensation since 2017 when I started at a defense firm. I stayed with that firm where Mike Johnson actually used to be until July of 2021, when Mike convinced me that I was on the wrong side and I should come and do some good for a change. So I came over, and I actually got interested in workers' compensation from taking the class in law school, though. I graduated, and I had from William Mitchell, and had taken the class with two of the partners that the old firm that worked at, and really enjoyed the odd stories that would come out of it. I think is what really drew me into it.
Now, what was your grade? What was your grade in the class?
I don't remember grades in any of my classes. I passed. That's all that matters now.
Just pass.
Oh, but it's workers' compensation. How do you not know what grades you had?
I'm gonna go with an A-, I think. Yeah. I know I did well in that class.
We can always pull the script.
So I have to say I've never done a podcast before, and the only thing that comes to mind as we're doing this is NPR Delicious Dish, or the SNL skit where they're talking about food with Molly Shannon.
We need to talk in a more whispered voice.
Exactly. That's all I want to do right now. But arising out of and in the course of, that's the really one of the basic tenets of workers' compensation claim. And The arising out of has to basically means that it has to be a causal connection between the work injury itself and the work that you're doing. And there's the test for that is
It has to come out of both.
it has to come out of both, arising out of and in the course of. The in the course of means that you have to be actually doing something in the furtherance of the benefit of the business or the employer. There are a lot of exceptions to that. I know Eric has a favorite story about a smoking Santa that he enjoys in the smoking exception.
That
Um,
that's like our Christmas time story.
yeah, that. But we'll get to
previewing
that
yeah.
eventually. Yeah.
Yeah.
But that's just one of one of the main things that you have to have. The injury has to be related to the work that you're doing, and it has to be while you are doing the work for the employer. Basic definition.
Okay. Well, I mean, I'll take that A- definition. That's fine.
It was an A-
It's-
definition.
It works.
Maybe B+.
Okay. Well, I suppose I should probably give a little bit about my background. Much like these two, I came from a defense firm. I was not at the same one they were, but I came from the defense side originally. But before that, I took a little bit of a different path. I actually started out being introduced to workers' compensation by having my own work injury that actually happened 10 years ago this December. So we're coming up on the 10-year anniversary of that. I was a store manager at Super America in some very, let's say, interesting neighborhoods. I think that's a
R.I.P. Super.
yeah. I know it's not Speedway. It is what it is. Anyway, I had my own work accident. It introduced me to workers' compensation. I then used what I learned going through the process to actually become an adjuster and was handling these types of cases when I went to law school. While in law school, I did do workers' compensation as a class, and I will say I did get an A. So, not to credential shame you or anything at this point, but throwing it out there. I did not get the highest A in the class, and the plaintiff's attorney that I'm sure made that happen, you know who you are. So, so anyway, one of the things I really like about workers' compensation, and one of the reasons why I wanted this podcast, was because there are weird stories in workers' compensation that come up all the time, and there's just not a good place to tell them to people that don't do workers' compensation on a regular basis. So I was feeling a little bit inspired because, it's just fishing opener. I've been out fishing a couple times already. So I kind of wanted to talk about some of these fishing cases. You guys fish at all, by the way?
No, absolutely not.
I like to
No.
claim that I do, but I don't do it well. I bought a fishing pole for my daughter. I bought a fishing license. Have not caught anything for probably the last year.
That makes me sad.
Well,
That's okay. I'll take you out sometime. We'll catch something big. All right.
can we do it during work and have a hook go through our finger?
You know what? We can talk about course and scope in a minute there, but that's an okay segue. So, I have 3 different workers' compensation cases. 2 of them are real, 100% happened, Minnesota workers' compensation cases. 1 of them I made up. Now, the trick is I'm going to give these cases to these guys over here. We're each going to take turns reading one of them. We'll break down kind of the workers' compensation aspects of these cases, and then we'll figure out which ones are the real ones and which one is the fake one. And I'm hoping I can trick one of these guys. So here, randomly take one here. And then I want like a good dramatic reading. Like I want to feel like I'm watching something good here. So Scott, do you want to do the honors on this one? See if you can-
Sure. So the 1959 exploding dock. See, I'm just going to use my child reading a story at bedtime. I think is going to be good for this.
Good. You probably shouldn't read these stories to your child.
No, they're going to be gruesome. The year is 1959. The employee was a mechanic / service manager / parts manager. The job also included welding. A number of local townspeople, some of whom were customers of the employer, formed a boat club. The members of the club began constructing a floating dock. The dock was to be used primarily for boating. However, fishing was allowed on the dock. The employee was approached at work by one of the members to see if he would help on the construction. The employee agreed to assist. The construction of the dock involved welding some large barrels together as pontoons that would help the dock float. The employee was not a member of the dock club, but did use the partially completed dock for fishing. The employee never received permission to donate the employer's services without compensation, and the employer had no idea the employee had undertaken the project. On the date of injury, the employee had completed his assigned work and did not have any projects to work on. He began spot welding a barrel that was to be used on the floating dock. While working on this barrel, there was an explosion due to pressure and gas buildup in the barrel. The employee survived the incident, but ended up with significant injuries.
Yeah. So
Two
Would-
major issues.
go ahead, jump in.
If you're volunteering and not being compensated, you're not considered an employee within the definition of the statute, not entitled to compensation. I think that's the biggest one here. Also thrown in the fact pattern towards the end was that on the day in question, he had already stopped working for the employer, which was the boat service company, and then he went to do this volunteer project for the boat club. I think they're trying to hook. So those would both tell us that he's outside the course and scope of employment, and he's probably not an employee of the boat club definitionally. I think the hook that they're trying to drag you back in and slip you up is the fact that he used the dock for his own fishing activities. I don't think that's a hook, really. I think it's a try at a hook.
And the fact that he was using, equipment provided by the employer, in theory, was, the welding gun. Or welding gun, is that the right term?
Yeah.
which may have affected it if the gentleman in question had been receiving compensation and was using the employer's tools. There could be an argument to be made that there was an employment relationship created with the boat club or some sort of independent contractor thing going on. But
Yeah.
I think that those are all red herrings. I think that what should have been the correct result in this case, in different era, different court, but I think it should have been held that he was not an employee of the boat club. He was a volunteer, and even if there had been an employment relationship created with the boat club at the time of the injury, he was outside of the course and scope of employment, as he had finished his employment for the day for the dock.
So now I'll throw some additional facts at you. Not saying these are real, because this one could be the made up one. I don't know. But a couple of additional facts. The underlying case was against the parts service managing that employer. It wasn't against the boat club. And one of the questions that probably needs to be asked and really isn't necessarily answered just by itself in the facts that we have is, did this benefit the employer in some way? So we have a guy that's done working. So you think, okay, he's outside of his course and scope because he's not actually working anymore, but he's still on the premises, and the activities he's doing actually might benefit the employer, which may put it back in the course of employment. But because we have a situation where the employer doesn't know that there's a benefit, I think that's the issue that's trying to be resolved in this case.
And they're not directing what's being done. The employer isn't. I think that's another.
Didn't even have knowledge of it.
Yeah, they didn't even have
Yeah.
knowledge of it. So I mean, they don't. Like you said, they obviously don't know that it's happening, and they don't know that what the benefit could be. Now you think about it, it's like, well, it looks goodwill for the community that they're trying to build.
Yeah. So if I was representing this person, my legal take on it would be, and what we'd push in court is, I would try to argue that even if the employer didn't know about it necessarily, they're still benefiting from the work. It is still, a work-related activity, and the injury obviously happened while physically at work. Now, does that carry the day? Probably not. But that would be the argument we would make, and a judge, I think, conceivably could go either way on it.
I think the benefit's tangential though, right? Because the benefit would be by helping improve the boat club's dock, the marine service company could potentially, I guess, get more business.
Yeah.
I think that's too tangential for me. It is interesting to me though that they actually sued the Marine Service Company and not the boat club. I mean,
Right.
if you were gonna sue this out today, you'd sue out both of them and make them fight separately, and they'd each have their own arguments again. Um, but it's interesting that he only sued the guy who was cutting him checks when he was doing something that was without the knowledge of his employer, wasn't being compensated for it. So that's interesting.
All
I
right.
still say no.
I say no on this one too.
I'd probably
Whether
agree with you. I'd make a good argument, but this is probably a
whether
no.
it's real or not, or which one's the fraud, we're gonna have to hear the other two, I think, to get a better idea.
All right. Well, great segue here. Let's do. Mike, do you want to try and read yours?
Sure. So this is called the 1944 dam accident. So the year is obviously 1944. The employee is working in sales for a local seed company. As a seed salesman, he frequently takes farmers out for various activities to increase his customer relations, basically market them. He would take farmers out drinking and was reimbursed by his employer. He'd be reimbursed for those costs. In addition to having an alcohol budget, he also took out farmers on one of his 3 boats. So one day he took, he took them, I guess, out for both hunting and fishing purposes. Hopefully without the alcohol, but I think we all know that's probably not true.
Probably not.
These are Minnesota cases.
Not as much wrong with fishing and alcohol as mixing hunting and alcohol. He entertained prospects so frequently that rather than being reimbursed for individual expenses, he was given a stipend of $25 per month to do this sort of entertainment of prospective clients, which comes to about $375 in today's dollars. So imagine if you had that sort of monthly budget to take out prospective clients. On the fishing opener in 1944, the employee took 2 farmers out on his boat. This occurred during his normal working hours. He had previously sold seeds to both of the farmers. They were able to fish most of the morning, but they got caught in a current. The current took them towards a dam on the river, and the boat went over the dam. The employee and one of the farmers passed away as a result of the incident. And I guess we can presume the other one had injuries and had a claim for them.
Yeah. I'm not sure what happened to the third person on the boat. But
we're going to be
like,
looking at this as can the seed salesman recover?
Yeah.
Right.
Yep. This one. So the case is for the seed salesman. My first thought looking at this case is I did not know seed salesmen were like that important, like as far as like salespeople, like to have a budget like that and to have the ability just to go out on one of your 3 boats. Like I did not know that seed salesman was like that type of profession.
I want to know how he got 3 boats.
Well, you
only need one.
Well, I mean, if you're making good green as a seed salesman,
you got to think about the time too. I mean, one was probably a duck boat because it says hunting, right?
Yeah.
One was probably some sort of early model speedboat, like tooling around boat, and the other was probably more of an outboard fishing boat, I would guess.
Yeah,
fair enough.
But yeah,
just get a pontoon. You can accomplish everything.
I don't even know if they were around back then, because didn't they pontoons themselves kind of get invented in World War II?
Maybe.
So
I'm not a pontoon history buff, but I know welding can cause issues, so maybe they weren't making them then.
Yeah.
But no, so issues in this one, what I'm seeing is it's another course and scope question, because was he working at the time of the accident? Was he in the course of his job? And a lot of the facts laid out that he, as part of his job, did these type of entertaining activities. So to me, this is a pretty straightforward, this was part of the job. All the underlying facts suggest it's part of the job. This one sounds compensable to me. It sounds like an injury that should be accepted and benefits should be paid.
I entirely agree.
I think that one of the questions that would have to be answered, though, by the judge, with the facts, is they need to find out, were they going out as just as friends that day, or was he trying to go out and make a sale to them again? Was his goal of going fishing and hunting to continue that relationship selling seeds, or was it just merely to go out and hang out with his buddies and get away from work, even though he's supposed to?
And given communications at the time, I don't know that you'd have good good enough contemporaneous evidence of that.
Right.
I think it would have to be a pattern of behavior type of thing. Like he had done this before. This was a regular sales technique used, and this is not uncommon today. Maybe not going boating as much in seed salesmen, but anybody trying to make a sale, taking someone out golfing, you could just change the facts around to that, and let's say the golf cart rolls and someone dies.
Right.
To me, it's clearly furthering a business interest of the employer, which keeps it in course and scope. It's during normal business hours, even if it was past normal business hours. I think, particularly given that the work is sales and so relationships are so important. I think it's compensable. The one other thing we didn't talk about that I don't know if you want to touch on was the intoxication issue.
That's true, but I think you're going to have a hard time proving intoxication in this case because there is an intoxication defense. I'm not sure if it was even around in 1944. I'm not sure on when it was put in the statute. But the intoxication defense is that the intoxication is what caused the work injury. It's not a particularly great defense because even if he was intoxicated, but he was just a bad boat driver and that's what caused it or something like that, you're going to get past that. So, I don't want to tell people it's okay to be drunk at work because obviously it's not.
And
But-
don't drink and drive boats.
Yes.
Right.
Don't disclaimer, don't drink and drive, don't come to work drunk. Don't do any of that. But the intoxication defense is one that can be raised, but it's one that's pretty easy to overcome. There's a lot of case law that shows accidents that are pretty straightforward and you would just logically assume were caused by alcohol, and that's just not how the court rules. That's not how they see them.
Are we going to do a trucker episode?
We'll probably have to do it.
We have to do a trucker one because there's a great case that an attorney at my old firm, he's retired now, had. And the employer was J.R. Schugel, which is a very popular trucking company. People will see, if you live in Minnesota, you'll see them on the road all the time. And the facts with intoxication and the particular facts of that case are just unbelievable.
Yeah, it's a crazy case.
We don't need to do it now, but
I also very much enjoy that case.
Yes, I do. I like talking about that one. But yeah, I think we can probably wrap this one. I think that this is compensable.
I would agree with that.
Yep.
Now, Eric wrote these cases out. So one thing I'm going to point out, little detective, is he says this occurred on the fishing opener in 1944, and earlier he said he wanted to talk about fishing cases because the fishing opener just happened. So is there a little Freudian slip there? Maybe. Just might lead us to know that one might be made up.
Are these summaries of the case, or this isn't verbatim written, right?
No,
this I don't think in 1959 they'd be using /mechanic/serviceman.
So I had the case up on one of my screens, and
Okay.
I was summarizing on another. So I was reading it and typing it at the same time.
But it's
So
your input into the summary a little bit.
it is. I
Right.
did do some input. So, but we're not done yet. We still have one
We got
more.
one more.
So you got to think about it. So we've got the exploding dock, the barrel that exploded while the guy was welding it. We all said that's probably not a work injury. We have the 1944 dam accident, and one of the things that came up in that is when are you in the course and scope as a salesman? So I'll continue that thought here, and let's talk about the 1931 Fish Shack Fall. I wrote these so I can be a little bit more dramatic while reading these. The year is 1931. The employee worked as a salesman / branch manager for a machine company. The employee hires and manages salesmen in Minnesota, North Dakota, South Dakota, and Wisconsin. As part of his job duties, he regularly travels around his territory. The employee began a work trip and took his golf clubs and fishing tackle along. Which, by the way, right there, that's a sign of a smart salesman. Like, you're going around the area, yeah, you take the stuff. He planned on traveling to North Dakota and would speak with contractors and business prospects along the way. The employee met up with an acquaintance, a druggist, in order to learn more about a potential business prospect. Now, druggist, obviously, they're not talking about a drug dealer. We're talking about a pharmacy person.
Thank you.
That's true. Like, I didn't want to bring up the illegal defense because obviously, if you're doing crimes, it's outside of your course and scope of employment. So no, this was a druggist that gave out legal drugs at the time. The contact he met was not a prospective client. Rather, he had insight into a potential customer. The two went out fishing for the day and returned to the fishing cottage of the druggist. When they arrived at the cottage, the two noticed that the kitchen pump was not working. Now, what is a kitchen pump? I'm not sure exactly, to be honest. Don't know. I assume it probably brings water or something like that into the kitchen. My best guess, based on the context. Not saying this is a real case, but based on the context. They undertook steps to pull the pipe up. So they're trying to pull this pipe up through the roof. The employee went on the roof to pull the pipe up through the cut hole and lost his balance, and he fell off the roof, fracturing his foot. Complications set in, and the foot, as well as part of the leg, were amputated. So that would be the 1931 Fish Shack Fall #3 case. I really like the face. So for those of you just listening and not seeing the video here, the face Scott was making there was just like he was just lost. Like I just completely lost him in that one.
I don't think that would be compensable. It's too far removed from the scope of his duties.
But you have the traveling employee exception. So an employee who's temporarily traveling in order to perform their services are covered what's called door to door. So there's a case from probably 30 years ago where a higher up muckety muck at some company, a VP of HR or something, was at a conference in Mexico or Costa Rica or something, a professional conference. And there was a break in the conference. I think we've all been to these at some point in our lives. And he, probably not in as nice of a place, but he goes to his hotel room during the break. And then it's like hours later, no one can find him. They get hotel security. They go in and he's passed away in his bathroom, presumably from a heart attack or a seizure or some other normally idiopathic condition.
Right.
But because he was only in those circumstances where he couldn't be found to get prompt medical attention, whereas he would have if he had had that incident occur in his office, the court held that he was covered by the traveling employee doctrine, and that even under today's standards of having to demonstrate an increased risk, that he was at an increased risk of injury because of the fact that he was secluded in his hotel room. So this is definitely a hard one. I think that if this had happened at a hotel room, I think this would be covered. The fact that it occurred at the lead on a client's house. I mean, that's really what it is. It's not even a client's house. While you're attempting to help this person fix a component in their house.
It's just a simple plumbing issue.
Yeah.
It's not part of his job at all.
Yeah.
And at that point, again, are we really furthering a business interest? You've already done your entertaining of the gentleman, hopefully done a good enough job doing that to get the recommendation of where to go.
Now, could you make the argument that by helping out, he was also trying to further helping the guy and getting that information from him too?
I mean, I think you could, but I also think that the analysis of this changes if we're talking about a client's house. Because, I mean, at what point does this become more of a social visit than it does trying to get information on a prospective client? I mean, he spent the whole day out on the boat with the guy, goes back to the cottage, and they're still together. So when is this friends hanging out and you kind of stop working, quote unquote, or does it just kind of continue indefinitely? And then on top of that, you have the factor of you're not even doing activities that would be reasonably expected for a traveling employee. So one of the other things with the traveling employee is most of your activities are going to be covered. So if someone's staying at a hotel for work and they go out and they go in, let's say, the exercise room and get hurt on a treadmill, that's probably going to be covered because when you're traveling, it's pretty well expected that you can exercise and do things like that. did they really expect him to go up on someone's roof? So to me, these facts get a little bit tricky. Obviously, we're going to argue for the employee in any case, but in this case, it might be just a little too far removed from his normal work to be accepted.
This is also one where I think it's a little bit of a generational issue, and we'll talk about that throughout the course of multiple podcast episodes, is how workers' compensation evolved from being a remedial statute, meaning if you had close cases like this, the courts were instructed to find in favor of the injured worker.
Right.
And that was repealed about 20 years ago now, or 25 years ago now. So that standard no longer applies, and actually the employee has the burden of proving their case. This is one where I kind of see it as a 40-60. I think it's 40% proven and 60%, nah, there's too many tangential items here. I deny it.
I would agree with that. I would go up to 25-75.
And this one I think is real. So I'm guessing the damn one is the fake one.
All right, let's get the guesses on which is real, which is fake here. And tell me your reasoning. So you guessed the damn one. Why do you think the damn one's not real?
Well, the little Freudian slip I alluded to earlier, but also I think some of the terminology, like kitchen pump, and us not understanding what a kitchen pump is. If you wrote the story, you would have known what a kitchen pump was.
Or
Or
he
what-
could be lying.
You could have described it. So
That's true.
that's why I think that one's real. I also think that the exploding dock, that's just too good to not be true. I mean, that sounds bad, but somebody just trying to, I'm out of work at my job, I know how to weld, I'll go take this and help this boat club out. It's so Minnesotan, and
Yeah, very much so.
that I think it's got to be true.
See, I think the damn accident is true because I vaguely remember reading a case similar to that. I don't know if it was the exact same or if it was similar. Just can't recall that right now. But it sounds familiar. So I think that one is real. I think the exploding dock is fake.
Why do you think that?
Because you have to pick one.
Exactly, because I have to pick one. And that one, I like the kitchen pump analysis there.
Mhm.
None of us know what that is, and I don't think that you would make that up.
Okay. All right. So those are the ones you guys are comfortable with locking those in?
Yep.
Okay. So, because no one picked it, I'll talk first about the Fish Shack Fall. It's a real Minnesota workers' compensation case. So one of you is correct because it's the real one. Yeah, good job. So in the Fish Shack Fall case, what the court really made their determination on is they looked at this being a way to get information about a prospective client and not being a prospective client, and their ruling was, and it really sounded like they were trying to get the employee benefits. Like, I think they really did what they could to try and get the injured worker benefits. And what happened is they said, you know what, the going on the roof of the kitchen pump was just kind of the thing that went too far. I imagine if he fell in the kitchen or something like that, they probably would have gone a different direction. But here they said, look, he was up on the roof, a little bit too far, not compensable.
And certainly if he'd gotten hurt in the boat, like the dam story, I think that they would have awarded him benefits.
Yeah, it would have been a very similar situation.
Yeah. All right, well, let's talk about the dam story. The dam story, also a real Minnesota workers' compensation case. So, Scott, you were correct on that.
Oh, yeah,
So the dam case, what they were really looking at is, that the individual was promoting the business. It was an accepted part of his job. It was during his work hours. So they were going to award benefits there. They were pretty straightforward on it. They went for it. It wasn't too much of an analysis by the Supreme Court on that one. They just said, yeah. Now, the 1959 exploding dock, it is not a real Minnesota workers' compensation case.
It's got to be based on something that you read in some obscure workers' comp history book or something.
However, it is a Missouri workers' compensation case, which I tweaked slightly. I added kind of the fishing parts in it, but it's generally what happened in a Missouri case. And the Missouri court actually analyzed it very similarly to how Minnesota would. So when they looked at it, they see that the employee was on call 24/7. He acted as a manager sometimes, so they're thinking, okay, could he make this business call? But ultimately said no, and the reason they came up with it was because the doc didn't benefit the employer. Now, they might have looked at it differently had there been like a sign saying, doc donated by whatever company, because he as a manager theoretically could make that determination. But at the end of the day, they said no benefits. The employer didn't know about it, didn't really benefit the employer. But they really looked and tried to figure out how to award benefits there. The court was looking for a way to award benefits. They just couldn't find one.
The dock increases boat usage, then you have more boats. They need more boats to do more repairs.
He should have, and I don't, God knows if they ever did. But after the decision came out, then they should have turned around and sued the boat club in tort.
Maybe they did.
I mean,
I don't know that part.
There had to be some sort of negligence for that thing to explode. Whether it was all the guy's negligence, very well could have been, but or even in that case, he could have sued the employer under a gross negligence theory if it was something to do with the equipment.
Right.
See, that's what happens with lawyers. We're just finding different ways and different people to sue everyone.
Or the equipment manufacturer for a design defect. Yeah.
There you go.
We only practice in workers' compensation, by the way. Like, that is our only area, but we still like to sue everyone.
The three of us, that is.
Yeah,
our firm handles other areas.
Yes. All right. So, we went through the cases. I think the big takeaway I wanted from the cases today is I want people that don't know workers' compensation to know that just because you're not physically in a workplace does not mean you're not in the course of your employment. A lot of people do things outside of your normal workday that benefit the employer. And if you have an injury, it's very possible it should be compensable, which means it's approved and should be paid. So kind of the takeaway today. You guys have any other takeaways you want to add in before I preview next episode?
On that same vein, people that are working from home. So many people have gone to basically full-time work at home since COVID that understand the facts in your case are going to be very important as to if you have an injury at home, but during your work day, there's a chance that could be covered, and there's chances that wouldn't, and it's going to be very fact-specific, as we've kind of fleshed out in some of these cases. So don't think just because it happened at home that you shouldn't call an attorney.
Scott, anything? Any wisdom for us?
The only other thing I would say is that there's a lot of exceptions or factors to consider in arising out of it in this course of, even if you're going to the bathroom, that's going to be covered. There's a lot of things. Just taking a break, it'll be covered. Slight minor deviations if you're traveling, and we'll get into all that stuff in later episodes, I'm sure. But there's a lot more that goes into it. That's just a real basic overview.
All right. Well, and I agree with what these guys said, and if you have fact-specific questions, that's why we're attorneys and we're here to help. So next time, we'll be switching up gears a little bit. We'll be talking about a profession that we would not want to do. We actually have a segment, and we call it I Would Not Want to Be A. And in this week's I Would Not Want to Be A, I would not want to be a minor. And we say minor, we don't mean like under the age of 18. We mean someone that actually works in a mine.
I'd like to be a kid again. I'm not going to lie.
Yeah, I would too.
It's a whole different discussion. All right. Thanks for listening in and joining us in the land of 10,000 claims. Thanks. If you enjoyed that segment, please like and subscribe. Also join us here for regular updates and new episode releases in the land of 10,000 claims. Thanks.